Hola, muy buenas tardes a todas y todos. Les damos la más cordial bienvenida a nuestra primera sesión del Comité de Jóvenes Árbitros de ICC México. Como saben, nuestras sesiones se rigen bajo el protocolo de competencia económica de nuestra organización que encontrarán en nuestra convocatoria. Agradecemos su apoyo para mantener su micrófono en silencio y les agradecemos tomar nota que esta sesión está siendo grabada. Sin más, vamos a dar inicio, para lo cual le voy a ceder el uso de la voz a la licenciada Nora Cabrera, presidenta del Comité de Jóvenes Árbitros de ICC México. Adelante, por favor.
Muchas gracias, Laura, por la introducción. Bienvenidas y bienvenidos todos a esta sesión que estamos muy emocionadas y emocionados de tener el día de hoy. Es una sesión que habla de un tema que nos parece muy novedoso e importante, de unas reglas que hizo e impulsó nuestro ponente. Entonces nos sentimos muy halagadas y halagados de que esté él el día de hoy con nosotros para platicar de esto. Hoy es el día en el que vamos a lanzar varias iniciativas que tenemos desde el Comité de Jóvenes Árbitros. Les pedimos que nos acompañen hasta finalizar el evento. Les voy a platicar un poco cuál va a ser el orden del día. El orden del día será que en un inicio nuestro expositor, junto con Eric y Andrea, que moderarán el panel, platicarán respecto a estas reglas de las que no voy a adentrarme mucho más porque ellos nos harán el favor de hablar a fondo y a profundidad respecto al tema. Después procederemos a darles a conocer las nuevas iniciativas y cómo pueden formar parte todas y todos de estas iniciativas. Y pues cerraremos también con unas palabras por parte del presidente del Comité de Arbitraje. Entonces los invitamos y las invitamos a que nos acompañen hasta el final. Sin más, por el momento, sin más, para no quitarle más el tiempo a nuestro ponente, voy a proceder a presentar a nuestros dos moderadores de lujo y con quienes comparto la presidencia de este Comité de Jóvenes Árbitros, con Eric Clavel y Andrea Rivera. Eric Clavel es socio del despacho Clavel Abogados, es presidente del Comité de Jóvenes Árbitros y también es representante regional de ICC JAF. También nos acompaña Andrea Rivera, que es vicepresidenta del Comité de Jóvenes Árbitros. Por aquí también se están conectando todos los coordinadores que forman parte del Comité de Jóvenes Árbitros. Está Beatriz Valladolid, se encuentra también a Juan Carlos Villa, Javier Navarro, y se siguen conectando por aquí nuestros coordinadores. Muchas gracias por estar el día de hoy con nosotros. Y pues bueno, dejo a nuestros moderadores Eric y Andrea para iniciar con el evento. Perdón, antes de esto, tenemos el honor de que también nos acompañe el presidente de ICC México, Klaus von Boveser, que nos honra con estar el día de hoy aquí con nosotras y con nosotros. Tengo que decir que a veces no se puede conectar a todos los eventos, pero hoy nos hizo el honor de acompañarlos y pues le vamos a ceder el uso de la palabra para que nos dé unas palabras de bienvenida antes de cederle la voz a Eric y Andrea. Muchas gracias.
Muchas gracias, Nora. I will switch to English so our friend David Rifkin can understand what I'm saying. So very honored, Nora, to give a few words. I would really like to congratulate you and Eric for the program of the Young Arbitrators Group. You're doing an extraordinary work. I've been following what you're doing and really am very proud. And of course, congratulate Alejandro Barrio as well, who is the president of the Arbitration Commission as well, has joined the group. So thank you very much for inviting me today. It's a real pleasure, David, to be at this session where you will explain the town elder arbitration rules. I have heard about them, I've read them. I think it's a very innovative project, so I really wanted to have the opportunity. I don't know if you have given a few lectures on the point. I read in GAR the outcome of a speech you gave at GAR, and I know you have been I've read all over the place about that, but I hadn't had the chance to be in an actual session where you were speaking. So when I received the invitation, I very much were very honored to accept and to be with you today to listen to you. So thank you very much for accepting the invitation of our young arbitrations group, which were smart to be the first ones to invite you. So congratulations for the young lawyers who are always very agile in getting the best speakers. So it's really an honor that you will be with us today, and thank you very much for having accepted. So I look forward to listen to you, and then I give back the word to, I think, to Eric and Andrea or Alejandro Garrio. I'm not sure who's the next to speak. Thank you.
Thank you very much, Klaus, for your words. I'm going to change to Spanish right now, but thank you very much. También, antes de cederle ya por último la palabra a Eric y Andrea para empezar con la exposición, quisiera agradecer la presencia del presidente del Comité de Arbitraje, del licenciado Alejandro Garrio, que nos acompaña el día de hoy. También veo que está por aquí el licenciado Eduardo Siqueiros, que también le agradecemos mucho la presencia el día de hoy, y también Edgardo Muñoz, que tendrán ambos al finalizar, tomarán la palabra para darnos algunas palabras de cierre. Entonces, le cedo la palabra a Eric para que inicie con esta exposición. Muchas gracias.
Gracias, Nora. I will now switch back to English so that we can get started with the session. Of course, I join you in thanking everyone here at this session. This is the very first session of the committee in 2022, and we're super happy to have you all here. We have a great attendance, a great turnout. I believe we're almost 70 right now, 54 actually. And of course, being joined by Klaus Moberser, ICC Mexico's president, Mr. Alejandro Garrio, Jessica Gonzalez, everyone here. Thank you all for being here and for your support as well, because as you will see in the second part of the session, we'll introduce the new projects that we have for you, and without your support this would not have been possible. So thank you very much for joining us and for being here with us today. So as Nora said, the very first part of the session is just discussing and having a chat with David Rifkin, which I will introduce, and I will do so very briefly because if I wanted to go through all his accomplishments, we would need a whole session just to go through his resume, because let me tell you, his career is just staggering. So let me tell you a little bit about David before getting into the discussion. David is a graduate from Yale Law School. He's a partner at David Boyce. He served as a co-chair of the firm's International Dispute Resolution Group for more than 20 years. And in connection with his practice, David has handled cases and served as arbitrator under the rules of most of the major international arbitration organizations in the world. I would not have to name them because there are too many, but David has been there either as a party or as an arbitrator. He has notably served as well as an arbitrator in the panels for both Summer and Winter Olympic Games. In connection with other activities linked to arbitration, David he's a former president of the International Bar Association. He has sat on the board of the Singapore International Arbitration Center, the American Arbitration Association. He's a member of the International Council of Arbitration for Sport, which supervises the Court of Arbitration for Sport. He was the vice president of the London Court of International Arbitration, and many more. In terms of recognition, he's a Hall of Famer of the Legal 500, and he's recognized in major legal directories with clients praising him. And I got this quote. This is a direct quote from one of his clients. David is the best arbitration practitioner anywhere in the world. Full stop. That's how people regard David, and we're so happy to have him. And finally, as a fun fact, I know this, David, because I made a little bit of research on you. You're keen and you're a history buff. You like very much history. Actually, your major at Yale is on history. Is that correct?
That's right, Eric. Yes.
So as you can see, David is a true giant in the international dispute resolution area. And we're so glad to have you here as our first guest for this year to kick off 2022. David, thank you for joining us today. How are you?
Eric, fine, thanks. Thank you for that very warm introduction, and thank you for inviting me to join you. And I'm flattered that so many have decided to join tonight, including my long-term friends, Klaus and Alejandro and Eduardo. So thank you very much. Much appreciated.
On the contrary, David, thank you. So let's just get to it. So David, the topic today is town elder rules, these rules that you developed, that you've written. And it's, as we understand it, it's a new way or a different way to conduct arbitrations from what we're traditionally accustomed to. So in a minute or two, just give us a brief overview of how would you describe these rules and what value do they add to arbitration proceedings? How are they different from what we know already?
The rules, I wanted to provide a set of rules that parties could use to try to conduct arbitration in a different way, in a way that could be more efficient for many cases. And that is using a decision tree. The town elder rules, in short, rather than using the more traditional format that we use for most arbitrations, where jurisdiction, liability, and quantum are considered in one or two phases. Those phases are conducted, with usually 2 rounds of memorials, some document production, a hearing. The town elder arbitration rules instead proceed with more information up front. The parties and the arbitrators then decide what the issues are that need to be decided and what the best order is to determine those issues. And then they create a decision tree to follow through the case. And as I'll explain more when we get into it, the procedures in each step can be very different depending upon the particular issue to be decided. But the idea is to provide parties with an alternative to the more traditional form that we're used to conducting arbitration in, but to have something where parties and arbitrators can really think through the best possible way to conduct it, and rather than simply encouraging this form of arbitration, as frankly I've done in the past speech, I decided that it would be helpful to actually put forth rules that parties can look at and decide whether they want to use or not.
Hello, everybody. Thank you again for the invitation. David, it's truly an honor to be here. And again, thank you for your time. Following up Eric's question, I'd like to ask you, why and how are these rules born? As a result of a specific case you had, why did you decide to call them town elder arbitration rules?
So thank you for the question. I have been encouraging parties, counsel, and arbitrators to conduct arbitration in a more efficient way for a couple of decades. As many of you know, for example, at Debevoise, we issued the Debevoise efficiency protocol back in 2010. We updated it in 2018, which presents about 25 different procedures that might be effective in some arbitrations to save time, to be more efficient. And we were the first firm to make a public commitment that we would consider these efficiencies in every single case for our clients. So about 15 years ago, in 2005, 2006, I gave a speech in which that I called the Town Elder Arbitration Method. And the purpose of that was to encourage parties, again, not to use a standard procedural order number 1, but to think through in every case what procedure is actually necessary for that particular case, how much procedure, what kind of procedure, to use the experience that we've all gained, but to start every case with a blank piece of paper. And I called it the Town Elder Method or the Town Elder Model, because I hearkened back to the early days of arbitration a couple of thousand years ago, when you could see parties who had a dispute going to the Town Elder, and saying that they had a dispute. They wanted the town elder to help. Well, the town elder would not have reached in his drawer, and it would have been a him in those days, and said, okay, well, here's my procedural order number 1. Why don't you follow all these steps, and I'll see you in a year or two at the hearing. That is, that's the way too often we conduct arbitration now. And what I wanted to encourage people to do, what the town elder would have done is say, okay, you claimant, you tell me, what's this case about? You respondent, tell me why that's wrong, or do you have complaints against them? Well, how can we get to the bottom of this? Has there been anybody involved who I could talk to? Does either of you have any documents that might be helpful? You'd work through the process and figure out what the procedure ought to be for that. So I use this town elder idea to, again, encourage everyone involved in arbitration to go back to basics and to think about what procedure needs to be done in every case, and only that procedure. So I decided a number of years ago, I encouraged this decision tree arbitration model as one way of going about that. Again, focusing on what are the issues, how, if we resolve this one, maybe we don't have to resolve that one, how can we get to the resolution more quickly? And I began a number of years ago to draft some rules to illustrate how a decision tree arbitration could take place. As I mentioned, actually in the pre-call, Alexa von Vogesser, when she was working with us at Debevoise, helped me develop the first version of those rules. And then they sat on my desk for a little while until last year, when I decided to complete them and presented them at the ICC Institute's conference in Paris in November. And I decided to call them the Town Elder Arbitration Rules to harken back to that model, because it really is following the same model of thinking through at the very beginning of the case what procedure is truly necessary, and only what procedure is necessary for that particular case.
David, let me stop you right there. And just now that you mentioned the decision trees and efficiency, I would like to dig a little bit deeper into the rules, like vertically. So how do these rules work in practice? And could you please walk us through a dispute following your rules? And if you could use an actual case, it would be really, really helpful.
Sure. Well, the rules begin with, first of all, they use the UMSA rules as a base. So where the town elder rules don't have any provisions such as in appointing arbitrators, we simply rely on the UMSA rules as a broad, regular method that everybody's used to. The town elder process would begin with much more substantive pleadings at the very beginning. The notice of arbitration and the answer really ought to provide enough information that the parties and the arbitrator will be able to determine what the issues are and what the best way of going about it is. And so at the very first, so those two pleadings are submitted, and the parties and the arbitrator get together. This may work better with a sole arbitrator than with a three-person panel, simply because there's going to be a lot more interaction. The scheduling issues might be less, but it can certainly work with either one. But then at the very first meeting, the tribunal and the parties will go through the pleadings, we'll talk about the issues, we'll decide what issues need to be determined and what the best order is. And if, again, if you decide this issue, then we don't need to decide that one. So, it's a little bit like now when the parties might, one party or another, or the tribunal might wonder whether there's a preliminary issue that might resolve some issues in the case. But this takes it to a further step where it's not just one preliminary issue, but you can see how one issue might then lead to, or depending on how it's decided, might lead down one path or a different path. And so at the end of this first meeting, the tribunal, working with the parties, will develop this decision tree process. And then, by the way, I think we'll come to it a little bit later, but that first meeting involves not just the counsel for the parties, but a representative of the parties too, which is very important. We can talk a little bit more about why that's so later. Then you move to the first step, and within each step, again, the tribunal and the parties will decide what procedure is necessary for that particular step. It may be that witnesses are needed for that step. It may be that there are no witnesses needed. It may be that a round of submissions would be helpful. It may be that the issue is, could be decided simply through oral presentations. It could be that some documents need to be produced, and a document request to the other side might be relevant, or it might be that it would not be so. But depending upon the issue, the parties and the tribunal decide what the procedure should be for that step. They go forward, they have a hearing on that step, and then the tribunal issues a decision within a month after that hearing. That decision might be in writing, it might be oral, again, depending upon the nature of it, to let the parties know. The rules do encourage the tribunal and the parties to set the schedule going forward with the different steps, at least when the steps would take place, so that people could have hearing dates in their calendars and not deal with the inefficiency of trying to decide that later. But eventually you can move from one step to another. The tribunal may decide that, having made one or two decisions, that the decision tree doesn't work any longer and that a different decision tree should be put in place. That is provided for as well. Eventually, and again, in my experience, I've often found that through determining some issues early on, tribunal often gives the parties enough indication that they find a way to settle it, which is often, of course, the best resolution, because the parties know best what the business needs are of the parties. So I would expect that in many of these decision tree arbitrations, only a few of the steps would actually be undertaken before the parties would understand enough about the tribunal's thinking to decide the case, to resolve the case themselves. But if it goes to a final award after a number of steps, the tribunal would issue a final award, which could incorporate the prior rulings, and then make a final decision. So the case continues until it's finally decided, either as a result of a step, which may determine a final issue in some way, or through a settlement after one or more step decisions, or through a final award.
David, now that you've walked us through how do these rules apply, which has been very helpful, could you tell us if these rules should apply to all disputes, or what type of disputes did you have in mind when drafting them?
Sure. I don't think they should apply to all disputes. I think this requires a certain level of cooperation between the parties, which may not always exist. There may be cases where it simply doesn't make sense to break the issues down one by one in this way. But there are many cases where if certain issues of contract interpretation are decided early, or certain factual determinations are made early, it shows the parties are then able to apply those rulings to the other issues they may have in dispute. And as I said, they may settle it. Or it may simply decide enough of the dispute that, again, the parties can settle it without going through all the rest of the steps. So I could see this being used in construction disputes, where often there are claims and counterclaims, often 20 or more different elements of the claim. But here I could see it working very well, where you pick out one or two issues to decide early on that may give some indication about contract interpretation, may give some indication about facts and who's responsible for various delays, or simply, decide one element of the claim that is, that amounts to a significant portion of the total damages amount, and then the parties can deal with the rest. It may work very well in joint venture disputes where the parties really are not operating well as joint venture partners, and they need certain decisions made quickly in terms of, again, contract interpretation, or the rightfulness or wrongfulness of certain activities that, again, may lead out. So I think they're really designed for cases where there are both a multitude of issues that need to be determined, and where logically one determination may eliminate the need to determine certain other decisions, or again, provide the parties with enough of a roadmap that they will find a way to resolve the case themselves.
David, so if I understand correctly, so you're saying that basically you take the dispute, you go straight into the merits, and you just order them in a way that if the first step is decided, then you, how would I put it? You'll need to go further into that road, and then you move on to step 2, step 3, step 4, progressively, right? So I have seen in my particular experience that arbitrators are sometimes hesitant to review a case on an issue by issue basis, or split the case, or issue partial awards. Obviously, they're concerned about that because parties may try, particularly some parties, with this guerrilla tactics and everything, they may try to set aside these partial decisions while the arbitration is still ongoing and try to, sabotage the procedure. So how would you reconcile that potential problem that step decisions may bring about with the efficiency that these rules are seeking with the step decisions? What would you tell these arbitrators? How can they deal with that?
I think frankly, the problem probably lies more with the parties than with the arbitrators, because if both parties come to the arbitrators having chosen these rules, they've given the arbitrators all the authority that they need in order to make whatever decisions along the way they do, and not to worry that some partial decision would be seen as being prejudicial because they haven't heard all of the evidence or the other grounds that could potentially be used to overturn an award. I do think arbitrators perhaps need to be careful about whether they issue certain decisions as partial awards, which could lead to interim set-aside decisions. Sorry about that. But that's why often I think they don't need necessarily to put that decision in writing. They can inform the parties what it is. I think they have to be careful about not permitting a party to use a subsequent step to re-argue an issue that's already been decided. You certainly see cases where some awards are set aside on the basis that the tribunal had already decided on that issue finally, and therefore they are functus, and a later decision was invalid on that basis. But I think, I think that arbitrators' reluctance to use preliminary issues or to provide guidance to the parties during the case is one of the problems that arbitration faces today. And through these rules and through other speeches and articles I've written, and certainly others as well, we're trying to break that reluctance down to encourage arbitrators to think about this in a more proactive way. This does require a very active, involved arbitrator, an arbitrator who simply wants to have a procedural conference, issue a procedural order, and then see the parties at the hearing and read the papers the week before the hearing. That's not going to work for these rules. But frankly, I think given the need for more efficient arbitration and the and the cry of parties and in-house counsel to do so. I think parties are increasingly choosing arbitrators who are going to be more proactive and who are going to be, sort of active in each step along the way.
David, while reading the rules, a specific question came to mind. Sometimes arbitrators have second thoughts about asking specific questions to the parties, since the question may point out to an answer that could favor one of the parties' case to the detriment of the other. This often occurs in cases where the parties are not raising legal arguments that the tribunal thinks are applicable, and then the arbitrators have concerns that by asking those questions, they could be favoring one of the parties. So do you think that Article 11 of these rules, which expressly allows the arbitral tribunal to ask questions to the parties, resolves this issue? Is this an issue at all, in your view?
I think the issue you described is certainly one that can be a problem in arbitrations, and Article 11 was designed in part to make clear the authority of the arbitrators to step in, to be proactive, to express their views, and to ask questions. So yes, it was designed to deal with that. I do often think that the arbitrator's reluctance to offer views and ask questions is the fear that it could lead to overturning the award is overblown, because rules provide great authority to arbitrators now. They've all been rewritten over the last decade to make clear the arbitrator's authority to determine issues, to set procedures that they think are best and the like. Very often the parties, will specifically give the arbitrators a request to hear preliminary views at some point. We're writing that into our procedural orders as often as we can now, that at various stages along the way, even in a more standard format for an arbitration, that there will be interim conferences with the arbitrators where they may express their views on certain key issues. We do find, though, that arbitrators still have some reluctance to do so, even when the parties have authorized them to do that. And I think I'm hoping that reluctance will break down over time. Certainly, as a party, I'd like to know what the arbitrators are thinking. If they have read our memorials, the first round of memorials, and we have an interim conference after that step, they've certainly begun to come to some ideas about the issues in the case and who may be right and who may be wrong, or what they'd like to hear from one side or the other to defend against a certain charge. And if the arbitrators have some concerns or questions about my side's case, I'd love to hear that earlier and be able to use subsequent submissions or use the hearing to be able to answer those questions directly. So I think we can break that down. And Andrea, it's a good question. As you said, Article 11 is specifically designed to help break that down.
David, you were mentioning a few minutes ago about the party representative. You said that your rules require a party representative to be at the meetings with the arbitrators, and you think this was important. You underscored that aspect. And actually, Article 30 of the rules do require these party representatives to be there. What difference do you think it makes, and why did you make it compulsory to have in your rules? If the parties agree, they must have a party representative. Why do you think that's important, and how does it advance the efficiency of the procedure?
It advances the efficiency in a couple of different ways. One is that the town elder arbitration rules are designed in part to focus on the business needs of the parties. Do you need a quick, if it's a joint venture dispute, very often the joint venture parties are having problems operating the joint venture because they have so many disputes. So what issues need to be decided right now so that we can move ahead with the joint venture, even if there are other issues that need to be decided later. So at the very first procedural conference, the town elder rules provide that the party representatives will discuss their business needs. What kind of decision do they need? Do they need, similarly, do they need a long final award, half of which tells the parties what they already know about the procedure that was followed and summarizing the arguments and the like? or do they need something that is focused? What timing is required by them and based on their business needs? So having the party representatives there to be able to express that directly is very important. Second, I have often found either as counsel when I'm trying to do something creative in a case and I get opposition from the other side's counsel, that having our party representative and theirs at that first conference, where the arbitrators can then turn to the party representatives themselves and say, you know, we don't need to do this the way your counsel is telling you we could do this. We could do this in a much more efficient way. And I've done that as arbitrator, and I do request that there always be a party representative there for just that reason. You know, I've had the counsel come and, you know, with a very nice proposed calendar that has the hearing in 2 years. And the tribunal's uncomfortable with that and thinks we should hold the hearing in a year. Counsel want the 2 years because they want to stretch out the schedule because of their own conflicts or because they'll make more money that way or for whatever reason. But if the arbitrators are then able to turn to the party representatives and say, you know, we can get you a decision in a year instead of in 2 years, the party representatives inevitably say, that's great, let's do that. So it gives you the party's interests and the council's interest are not always the same. And having the party representatives involved in every step, including at the various step conferences where the procedures are determined for that particular step, always helps to make sure that the business needs of the parties and their interests are at the forefront.
Thank you, David. It's true that you've addressed a lot of concerns that we normally see in a standard arbitration, and it is very interesting. Also, another article that I found interesting was Article 13(2)(c) that requires the parties to explain their business interest and motivation in relation to the dispute. This article read in light of Article 2 that requires the party to act in good faith and collaboration. So should this rule apply, the rule regarding the parties explaining their business motivations should apply in all cases? Can a party decide not to disclose some of the information for confidentiality reasons or based on business strategies, maybe not necessarily related to the counterparty? Are these considerations relevant to arbitrators applying only the law? Can you tell us about that?
Sure, Andrea, it's a good question. I do think that it's important for the arbitrators to understand what the businesses need in terms of a decision. And in terms of the timing, the kind of decision, what are the issues that are important for them to resolve and early on. Yes, it may very well be that a party, you know, may have some information that it simply doesn't want to disclose. It may be that a party has engaged in the dispute for some reason that they don't want to reveal. And that's inevitably going to happen in some cases. But I think that doesn't stop a party from explaining their core business needs in a way that will help the arbitrators and the council figure out the best steps in the process, the best way of resolving that particular dispute.
Thank you. This is very useful. And following on, the Article 14.4 establishes that the decision tree is subject to change as the process moves forward, because it's so dynamic that it's not predictable how it's going to be. It's going to be solved in the beginning. So how is this change regulated? Should the same process for the creation of the decision tree apply, or can the arbitral tribunal impose a new decision tree?
Yes, again, it should be collaborative, and the tribunal should speak with the parties, but it may very well be that now that the tribunal understands the dispute more, or now that certain issues have been decided in a certain way, the framework that had been set up at the outset may not be the most efficient any longer. So the rules give this opportunity to revisit the issue at any point along the way. I think it wouldn't serve the town elder model. It wouldn't serve the concept to say that it has to be written in stone right from the beginning, particularly when this is really designed to be, not just like a bifurcated arbitration, but a case that is going to have a number of steps along the way, and where there be maybe more procedure in some steps and less procedure in others. We want to enshrine that flexibility and allow changes as it may be. Again, a decision in one or two steps may lead the parties to another way of thinking about it is it may lead the parties to decide, okay, we now have a better framework. We can talk about settlement. But now there's one more issue that's kind of sticking out there and keeping us from settling the case. And it's not the next one in the step process that was decided. It may be entirely new. It may be something that was already several steps further down the road. So, again, in those circumstances, the parties should be able to go to the tribunal and say, let's revise this. Now let's turn to what we really need decided right now.
David, one final question from my end, and this has to do with evidence. I see that Article 22 has a language in connection with the IBA rules of on the taking of evidence, which most of us are familiar with, and we know them as soft law. But in your rules, the wording is shall apply, so it's compulsory, it's mandatory, and I believe that, I guess that from your experience, you were very deliberate in those words. Why did you decide to make the application of these rules mandatory? Or, is that a correct assumption that they're mandatory? And if so, why did you decide to make them mandatory?
Well, the parties always have the opportunity to modify these rules. So they certainly could say, okay, well, we're going to follow Article 2 and 3, but not 5, or we'll use them as guidance. So I think there is that flexibility remains, but I do think that I wanted to take sort of the rules, provide some very good standards in terms of requests for documents. They provide some very good standards in terms of how experts and witnesses should present their statements. They don't really get into the substance of the evidence being provided, so there's that flexibility, but it takes it said shall rather than may, really frankly, to take one set of issues off the table. This is format, this is a standard. Let's focus on the more important issues that we have to decide. What is the list of issues? What's the right order to decide them in? How should we go about each step along the way?
Excellent. Thank you, David. These are some questions on our side. We'd like to ask the audience whether there's anyone who wants to ask a question, considering we have the author and the privilege of having David here. So we're going to open for 10 minutes for a question or two from the audience. I don't know if anyone's.
We already have one in the chat. So Galo, if you would, you can open up your mic and ask the question directly, please.
Yes, for sure. I can do that. Hello, everybody. My question will be, it appears to me that the town rules require constant cooperation and communication by both parties on all of the steps of the decision tree. How do you consider that the town rules might work against a respondent that fails or refuses to respond to a notice that a claimant is bringing an arbitration against them? Another similar scenario might be where a respondent initially takes part in the proceeding but ceases the participation at one of these steps or before the meeting of one of the steps. Should the tribunal's approach to conducting the arbitration change or vary? Thank you.
Thank you for the question. There's no doubt that the rules require a higher level of cooperation and good faith than may exist in some cases. I found arbitrators, under these rules would have the same power that they have under the UNCITRAL rules and under other rules to proceed in the absence of a party. So if I think it's unlikely that the rules would be used where a respondent fails to show up altogether. I've had cases like that, both as counsel and as arbitrator, and there the tribunal will want to conduct the case as quickly and efficiently as they can. They may often act as as interrogators and ask questions of the of the party that is there. But if a party begins in this process and the process is set up and then doesn't like one or two step decisions and stops appearing, again, the tribunal and the party that's there would have the opportunity to adjust the step procedures if there is going to be a more effective way to get to the end if the other side's not going to show up at all. Obviously, you have to continue to give notice to the other side. But the arbitrators could, have the power to continue the arbitration just as they would in any other case. I think the rule in these rules that says that the arbitrators have the ability to vary the steps and the decision tree along the way. There's also a rule in here that says that even if the parties adopt these rules, say in their contract, at that first procedural conference, if you have a discussion of the case and the issues that need to be decided, it may very well be that at that point the tribunal and the parties say, it was good that you provided for this in the contract, but now that we know what the dispute actually is, a decision tree arbitration is not going to be the most efficient way to proceed. So let's proceed in this other way, and that's fine. The rules, accept that because again, they want to allow for as much flexibility as possible. So I hope that answers your question.
Thank you, David. I don't know if someone else has some other questions. We have time for one more question, maybe.
May I ask a question? Okay, thank you. Hi, David. I'm Ana Garcia Moreno. I work at Hogan Lovells in Mexico City. Thank you very much for your time. And I have a question regarding Article 21 of the rules. It mentions that in connection with evidence, experts may submit joint expert reports. So how would this work in the practice? Do the parties agree a set of questions or issues in advance, or how do they determine the scope of the report? I mean, maybe in very complex cases, it would be very difficult for two experts to maybe agree on the issues. So I would like to know, how does this work?
Sure, and this is a procedure that's being used in some cases now, obviously outside of these rules too, where I guess in the simplest form, you see it often being used now at the damages stage, where each side may have submitted separate and different damages scenarios, but then the tribunal is going to use a DCF method, and the tribunal, they're not mathematicians, so they're not very good at creating a DCF model themselves. So too often, sometimes you see arbitrators say, well, we agree with this part of this model and this part of this model, and so somewhere in between it's this number, which is not a good way of doing it. So more and more you see arbitrators then saying to the parties experts, here are what we think the inputs should be into the DCF. Here's the pricing, here's the term, here's the whatever other factors go in. And you two now run the model together with these inputs, and then the tribunal can have comfort that they're getting a correct answer. We did that in the Occidental versus Ecuador case. We did that in the Hydro case against Albania. You see that happening a lot. But more and more, you also see, and I think Klaus Sachs has really pushed this proposal, that instead of having the experts submit entirely different reports, again, they are given a set of facts, or they're given the same set of documents, and they are asked to work together on as much as they can in preparing the report. And then there may be differences along the way. In some ways, it's no different from the kind of expert conferencing that goes on at the hearing, or the kind of meeting that often takes place after the experts have submitted their independent reports. Then they have to get together and submit and talk about the points on which they agree and the points on which they disagree, and submit a joint report saying where they agree and where they don't agree. I've used that method a lot. It really helps clarify for the tribunal where the real differences are between the experts, so that the tribunal's questions can really focus on in those areas. But in a construction case, you could see giving experts to both, given the basic documents in terms of the delay issues to both experts, and saying to them, you work out a delay model together in terms of what caused this portion of the delay, what was the consequence of that, and so forth. So again, it requires more cooperation, but it's something which is being used increasingly to try to get away from the fact that parties, experts often take two very extremes and don't therefore provide a tribunal with as much useful information as they might otherwise.
Thank you very much.
David, thank you very much for responding to all of our questions and for your time. It has been truly an honor to have you here, and a privilege to listen firsthand from the author of the rules. How are they applied, the motives behind them, and how they truly help address arbitral disputes in a much more efficient and practical manner. These rules are a result of your outstanding career and are a very practical and helpful tool for the arbitration community worldwide. Thank you very much.
Andrea, thank you, and Eric, for both of you for your questions, and for the committee for inviting me. I really do hope that as young arbitrators and working with increasingly younger clients as well, that all of you will push for greater innovation in arbitration, whether it's through technology or through using very different types of rules. It's in your interest that a decade from now and 2 decades from now, the process of international arbitration look very different from what it does now. And Frank, one reason why I finalized these rules now and did not do it a few years ago is it would have been much harder to undertake this kind of arbitration pre-pandemic, before we got so used to conducting hearings through technology. But now the fact that you can have such regular interaction so easily in the course of an arbitration, it makes this kind of arbitration possible. And I hope that all of you will encourage your teams, your clients to use these procedures. Again, they don't need to be used exactly as they're written. They can be used as just as a way of thinking about going back to the old turnover model. How should we structure this particular case? And I look forward to hearing stories about cases that are conducted this way, and wish all of you good luck, and look forward to working with many of you in your future careers.
Thank you so much.
Thank you so much, David.
And before you leave, David, I don't know if we can just take a picture with you. It is a true honor, as Andrea said, and we have so many distinguished guests today that I would love to take a picture of all of us. So the ones that want to be in the picture, please turn on your cameras. We'll be so happy to take a picture. I can take it. So ready?
Yes.
I think a lot of and are turning on the cameras.
Okay, I'll wait. I'll wait just, oh, give me 1 second to. There you go. Thank you. Thank you, everybody. David, thank you so much. It's been a true privilege. And now we will switch back to Spanish because we have, thank you, David. Keep in touch. We will switch back to Spanish because we have a few surprises for you. Nora.
Perfecto. Bueno, well, thank you very much. I don't know if David is here, but well, thank you very much. Bueno, cambiaremos ahora al idioma español y a presentarles, esperemos que de una forma muy rápida y concisa, algo que estamos muy emocionadas y emocionados de platicarles y que tiene mucho que ver con seguir con esta comunidad de jóvenes árbitros y buscar los mayores beneficios para que todas y todas quieran seguir siendo parte de esta comunidad y podamos hacer una comunidad cada vez más y más fuerte. Vamos a presentarles a 3 iniciativas que tenemos el gran gusto de compartirles el día de hoy. Yo voy a empezar a explicarles una de ellas. Me va a permitir compartir por aquí pantalla. Y pues bueno, todo lo pueden encontrar en nuestras redes sociales. Está en nuestras redes sociales que les pedimos que nos sigan para poder seguirlos de regreso, que es Jóvenes ICC México. Aquí vamos a subir toda la información de las dinámicas que tenemos para todas y todos ustedes. Está en post que están muy sencillos de poder manejar toda la información. Aquí está cuál es el paso a paso, qué es lo que hay que hacer, etcétera. Entonces, no voy a abundar mucho en esto porque en Instagram van a poder ver cómo formar parte de estas dinámicas. Pero bueno, una de las dinámicas que nos emociona mucho presentarles es una que llamamos ICC México Rewards. Y es prácticamente como si estuviéramos haciendo un tema de tarjetas de crédito, por llamarle de alguna forma, que lo que queremos hacer con esto es hacer niveles de involucramiento en las actividades de ICC-YAF y que en la medida en que ustedes se involucren más en las actividades de ICC-YAF, ustedes van adquiriendo un nivel dentro de nuestras actividades, dentro de todo lo que tiene que ver con ICC Jóvenes, el Comité de Jóvenes Árbitros, y los beneficios tienen que ver con todo ICC. El ICC México Rewards es este programa que busca dar recompensas a todas las personas que estén involucradas en el Comité de Árbitros de ICC México. Estas actividades específicamente son para todas aquellas personas que tengan menos de 40 años y entre más te involucres, pues más beneficios vas a tener y vas a poder sumar puntos. ¿Cómo puedes sumar puntos? Solamente te tienes que inscribir a este programa. ¿Cómo te puedes inscribir al programa? Aquí mismo está el enlace en el que te podrás inscribir. Aquí está un Linktree que ustedes pueden dar clic. Aquí pueden ver inscripción ICC México Rewards. Se meten aquí y van a poner de una forma muy sencilla, poniendo su nombre, su apellido, su correo electrónico, ser parte del programa y empezar a sumar puntos. ¿Cómo pueden sumar puntos? Aquí mismo en estas imágenes que subimos a nuestras redes sociales podrán verlo. Pues hay diferentes actividades para poder hacer puntos. Asistir a conferencias del comité, referir a algún miembro al comité, participar en el ICC Mood, escribir un artículo, y aquí pueden ver otras actividades, ¿no? Pueden cursar o aprobar algún diplomado de ICC. Hay muchas formas de ir sumando puntos. En la medida que ustedes vayan sumando puntos, van adquiriendo el nivel. Tenemos nivel azul, nivel bronce, nivel plata y nivel oro. Cada uno tiene beneficios diferentes. Si logran llegar a nivel oro, hay la verdad que beneficios muy interesantes, como un 20% de descuento en todas las sesiones de las comisiones de ICC y en los diplomados de ICC. Así que están muy llamativos que podamos alcanzar este tipo de niveles. También es importante mencionar que hoy empezamos a hacer puntos con un punto, acumulando un punto por haber asistido a esta plática. Entonces, lo único que tienen que hacer es registrarse para empezar a sumar puntos. Cualquier duda que tengan la podemos aclarar al finalizar la presentación de las otras iniciativas y también en redes sociales, que les repito, la cuenta para que nos sigan es Jóvenes ICC México. Estamos en Instagram y también en Twitter, pero por el momento nos pueden seguir en Instagram para que aquí estemos en contacto. Muchas gracias. Creo que la siguiente actividad nos la explicarán Andrea y Edgardo. Dejo de compartir pantalla. Listo.
Muchísimas gracias, Nora. Bueno, en seguimiento a lo que Nora les venía platicando, yo les quiero exponer una segunda iniciativa que nos parece sumamente interesante y novedosa. Por fin nos toca estar del otro lado de la mesa. Así es, nos toca fungir como árbitros. Como bien saben, el nombre del comité es Comité de Jóvenes Árbitros. Y en ese sentido, queremos impulsar y encaminarlos a un camino de preparación para fungir como árbitros en un futuro. Para ello, hemos creado este concurso totalmente novedoso y distinto a todo lo demás. Le denominamos Arbitrators Match. Y para explicarles más a detalle sobre qué trata y en qué consiste, me encantaría sumar al doctor Edgardo Muñoz, con quien en equipo y en conjunción hemos logrado diseñar este concurso. No sé si Edgardo esté por aquí. Sí, lo vi, aquí
Gracias.
está. Hola, Edgardo.
Hola,
Me encantaría, ahora sí que nos hicieras el honor de explicar a detalle cómo funciona y en qué consiste, porque estoy segura que va a ser muy atractivo para todos.
Sí, Andrea, muchas gracias. Y antes que todo, gracias por la invitación y un saludo a todos los que han venido esta tarde. Hay que decir que este concurso es iniciativa y es desarrollado por Jóvenes Árbitros de México. Me han invitado por el honor que me han hecho y porque me lo han sometido un poco a mi opinión, y la verdad es que yo lo encontré algo fabuloso y probablemente por eso me invitaron para transmitirles el entusiasmo que yo sentí y las bondades que yo le veo. Es una competencia que trata de escribir laudos como árbitro único. Y el laudo que ustedes van a escribir, pueden inscribirse, ya voy diciendo las fechas, a partir de ya hasta el 15 de febrero. Es un laudo sobre el último caso discutido, abordado, litigado en el ICC México MUT, ¿no? Entonces, en base a ese caso del 2021, ustedes, con ayuda de un memorial de demanda y un memorial de contestación, podrán, siguiendo un poco las pautas de los laudos que tiene ICC para los árbitros reales, para los laudos reales, hacer un laudo en donde ustedes, probablemente con mucho interés, los que fueron participantes de la competencia, decir: a mí me parece que esta parte debió ganar en estos puntos litigiosos determinados, en uno en otro, ¿verdad? Como saben, los casos están hechos para ser argumentados desde el punto de vista de ambas partes. Entonces ahora van a experimentar esto que es estar del otro lado, como ya decía Andrea, y decidir la controversia. Hay unas pautas muy, muy claras que han elaborado el grupo de jóvenes árbitros. Y bueno, más que nada creo que esto es una gran oportunidad para seguir aprendiendo, ¿verdad? Las técnicas más benéficas para el arbitraje, en la elaboración de laudos, en la participación en los procedimientos, y probablemente en las reglas que David nos platicó también podamos encontrar algunos tips para ser implementados dentro de esta competencia. Les digo para recapitular, les digo las fechas importantes. Estas fechas son de ahora al 15 de febrero, la fecha límite para inscribirse. El modo de inscripción, salvo lo que me digan los grupos, el grupo de jóvenes árbitros, es a través de la misma página que se les compartió, de los ICC México Rewards. Después hay una fecha el 1 de marzo para hacer preguntas sobre las bases de la competencia, y finalmente una fecha del 15 de abril, o sea que tienen 2 meses para elaborar su laudo y someterlo. Lo que me parece interesante porque eso es lo que más o menos tendría que durar un árbitro después de el último escrito sometido por las partes. Probablemente duran más, ¿verdad? Por la complejidad de los casos, pero eso sería lo ideal, ¿no? Un plazo de 2 meses, 3 meses después de el último escrito de alegatos. Y creo que eso es lo más relevante, pero lo más importante es que ganas puntos y que además hay premios independientes a los ganadores, a los primeros ganadores de este nuevo certamen de ICC México. Entonces, a reserva de lo que ustedes quieran agregar, solo agradezco por la oportunidad de intervenir y de transmitir lo que yo considero es un muy buen proyecto para continuar con este ejercicio de educar a las próximas generaciones de árbitros. Gracias.
Muchísimas gracias, Edgardo, y agradecerte a ti y a tu equipo, y obviamente a la institución, a la UPP, el acompañarnos y hacer realidad esta propuesta. Ojalá todos estén interesados, pues es una gran oportunidad y sin duda muy innovadora. Entonces, bueno, habiendo dicho lo anterior, les doy la palabra a mi colega Eric para platicarles la última sorpresa. Gracias.
Andrea. Ahí lo último que faltó mencionar, no sé si a mí se me pasó, pero el premio para el ganador del lado es una beca completa para un diplomado de ICC. Creo que es un premio sumamente atractivo, ¿no? Entonces, mil gracias. Y llegamos a la última.
Aquí antes de pasar a la última noticia, me gustaría nada más comentarles, ahorita les compartimos la página, pero aquí en la página que les habíamos compartido está las bases del del concurso que estaban comentando ahorita. Aquí mismo está la convocatoria y el enlace para la inscripción, para que vean que todo está de un muy sencillo acceso y que no piensen que es algo muy complejo. Está todo en la misma página. Aquí está.
Ahí abajo está el último botoncito donde se inscriben, abajo. Ese.
Sí, aquí está.
Buenísimo. Pues bueno, como verán, tenemos tres iniciativas. Todas son para que crezca nuestra carrera en arbitraje, para que crezca nuestra carrera en esta superindustria. Y pues como nosotros lo vemos es que la primera, la de los rewards, era involucrarnos un poquito más con la institución, que es, sin lugar a dudas, obviamente, la líder en arbitraje en México y el mundo. Innovamos y dijimos, queremos hacer una comunidad más fuerte a través de ese programa, que el acercamiento y el involucramiento con la institución les traiga beneficios tangibles. El segundo fue justamente cómo hacer que la institución fomente, que crezcamos en nuestra competencia, y por eso se nos ocurrió el match. Y el tercero fue un poquito de acercarnos un poco más a la gente que forma esta industria, hacer un poco más de comunidad y aprender de las experiencias de alguien más. Probablemente ya lo vieron en los snippets que les compartió Nora hace ratito, pero el último proyecto que les queremos presentar y que estábamos súper orgullosos de él porque lo hemos hecho con todo el cariño y el entusiasmo del mundo, es el podcast El Lado B del Arbitraje. Hoy lanzamos el podcast El Lado B del Arbitraje. Está disponible en Spotify. Lo pueden descargar ahorita, lo pueden escuchar en este mismo instante. Ahorita les paso el link para el podcast. ¿Y de qué se trata el podcast? Lo titulamos El Lado B del Arbitraje, las historias que no sabías del arbitraje. Ahí hablamos de asuntos, de despachos, abogadas, abogados, historias y todo lo demás. Tuvimos el gusto de justamente tener a nuestro presidente de ICC México y destacado árbitro, abogado, etcétera. Es un largo, etcétera, la carrera de Klaus von Boeser. Él es nuestro primer invitado, donde nos platicó justamente cómo empezó su carrera en arbitraje, cómo se enamoró de la industria, cuáles son un poquito los setbacks que ha tenido y cuáles son los consejos que tiene para nosotros como jóvenes practicantes. Estamos muy contentos con todo lo que nos platicó. Ya lo pueden escuchar hoy mismo en Spotify. y vamos a estar lanzando episodios cada 2 o 3 semanas con invitados de primerísima. La idea es que justamente nos acerquemos todos a través de ese nuevo canal y bueno, estamos muy emocionados. Ahí lo pueden encontrar todos, por favor, síganos, suscríbanse al podcast para que luego les lleguen las notificaciones en cuanto subamos el siguiente y así siempre estén ahí. Califíquenos, por favor, en Instagram, mándenos sus comentarios, sugerencias de invitados, sugerencias de actividades, algo que tengamos que cubrir en el podcast, por favor, díganos, estamos abiertos a toda la retroalimentación y la idea es que lo construyamos también con ustedes. Y como último punto también de este tema del podcast, es importante decir que ICC es una organización incluyente y por lo tanto hemos preparado una transcripción del podcast para personas que tienen discapacidad auditiva. Entonces también la encontrarán ahí. Toda esta información la van a encontrar en el perfil de Instagram, que va a ser el canal de comunicación con todos ustedes de ahora en adelante. Escogimos Instagram porque creemos que es la red social que está justamente a la mitad entre los jóvenes y entre los seniors. Creo que ahí es un buen espacio para coincidir. Entonces en Instagram lo pueden encontrar todo. En el link en la bio vayan y están la inscripción para el match, la inscripción para los rewards, el podcast, la transcripción, todo está absolutamente ahí. Entonces estamos súper contentos. Síganos, interactúen, lean bien ahí las bases, por favor, escríbanos comentarios, sugerencias, se los vamos a agradecer muchísimo. La idea es crecer en conjunto como comité y consolidar, o bueno, refrendar la posición que tiene ICC como líder en el mundo y en México como institución de arbitraje. De verdad, muchísimas gracias a todos y tengo el enorme gusto de darle la palabra a el licenciado Alejandro Garrio, que el licenciado, además, no solamente darle la palabra, sino agradecerle mucho por el apoyo que nos ha dado para estas iniciativas. Ellos las conocen, él, Klaus, Laurita, Jessica, todos los conocen y sin su apoyo estas no hubieran sido posibles. Así que muchísimas gracias y también muchas gracias por quedarse hasta ahora para darnos estas palabras de cierre. Licenciado, qué gusto.
Muchas gracias, Eric. Verdaderamente es un placer estar con ustedes acompañándolos en este que es un gran evento. Yo primero quiero felicitar a Nora, a Andrea, a Eric por el esfuerzo tan enorme y tan eficaz que han hecho. Voy a ir por partes. Primero quiero felicitarlas por esta reunión. Oigan, en la primera reunión que organizan ustedes en esta mesa directiva, traen a uno de los máximos árbitros en el mundo a que nos platique sobre su niño. Además, un niño que es impresionante, un niño que ha captado lo que es la esencia del arbitraje desde, podríamos decir, la época de la Grecia antigua, ha analizado las virtudes y defectos que tiene y ha pretendido de una manera absolutamente moderna tratar de resolver las dificultades que pueda tener el arbitraje moderno. Yo creo que las reglas de Town Elder son extraordinarias porque nos están regresando a la esencia del arbitraje. La esencia del arbitraje es resolver un asunto de forma rápida, eficaz y barata. No se trata de pasar años enteros en un litigio en el que, como dijo muy bien David, hay veces que los intereses de las partes y los intereses de los abogados no están perfectamente alineadas y eso lo sabemos. Yo creo que me llamó mucho la atención que en una reunión de jóvenes abogados pues se haya de una manera u otra tratado de unir ese llamado generation gap, la brecha generacional. Qué maravilla que en una reunión de jóvenes abogados estemos hablando de lo que pueden hacer los town elders, los viejitos del pueblo, las gentes que tienen la mayor experiencia, conocimiento y respeto de la comunidad. Pero no hay un gap, simple y sencillamente es algo que se puede tomar en cuenta para regresar a los principios básicos del arbitraje. Me encantó su reunión, me encantó el planteamiento de David Ripken, me dio mucho gusto verlo. Con esto la pandemia hacía tiempo que no lo veía y me dio un gusto enorme verlo. Yo, la verdad, no conocía las reglas de los Town Elders y cuando las revisé rápidamente me percaté de que hay una cantidad de cosas que, de veras, de utilizarse, tienen que acortar los arbitrajes, limitar los gastos y dar una mayor satisfacción a los clientes. Los felicito por la reunión. Segundo, los felicito por los planteamientos que han ustedes hecho. En primer lugar, oye, veía yo que llegamos a tener 66 participantes en esta reunión. No se dice fácil, ¿eh? Nosotros en nuestra reunión de la Comisión de Arbitraje de ICC México, es rara la vez que llegamos a 66 participantes. Eso simplemente es representativo del interés que hay en la comunidad arbitral joven de hacer acto de presencia, de estar presentes. Y cuando a mí me preguntan qué es lo que se requiere para llegar a tener los primeros arbitrajes, para ser conocido como árbitro, pues lo primero es eso, hacer acto de presencia, darse a conocer, estar donde está la acción, como es en este evento. Y las propuestas que ha hecho la Comisión de Jóvenes Árbitros, pues, ¿qué les voy a decir? Ellos ya saben que han sido analizadas por no únicamente la Comisión de Arbitraje de ICC México, sino por la directiva de ICC México, porque tienen un altísimo contenido de fuerza. Y siempre que hay fuerza, siempre que hay energía, tiende a haber un poquito de cuidado, de precaución. Aquí estamos en una serie de eventos en los que está involucrado el nombre de la ICC y se está poniendo el nombre de la ICC para que sea de alguna manera respaldado y cuidado por los jóvenes árbitros. En una reunión que tuvimos el día de ayer con Claudia Salomón, una de las cuestiones que se tiene como política, como de alguna manera idea muy seria, se ha hecho, pero ahora muy consciente, es la de cómo proteger el nombre de ICC, cómo aumentar su valor, cómo protegerlo de que se demerite. Y aquí estamos con el nombre de ICC llevando a cabo una serie de programas que son extraordinarios. Y me refiero a ellos. El de ICC Rewards. Qué increíble, ¿no? Yo creo que es muy práctico y muy objetivo el tener una manera de evaluar a los jóvenes árbitros. Como mencionaba anteriormente, para empezar a hacer carrera en el arbitraje hay que estar en el radar. Como ustedes saben, en la Comisión de Arbitraje de México tenemos el Comité de Propuestas. ¿Qué es lo que hace ese Comité de Propuestas? Cuando la Corte de Arbitraje de París nos pide el que propongamos a un árbitro para que sea designado por la Corte, pues nosotros tenemos que analizar ahora sí que todo el universo de árbitros, desde los árbitros con más experiencia, árbitros con menos experiencia, árbitros que comienzan. ¿Cuándo van a tener su primera designación los árbitros jóvenes? Pues, hombre, si se les pide el que tengan experiencia en arbitrajes ICC, nunca serían nombrados por primera vez. Entonces, a nosotros nos corresponde la tarea de identificar quiénes son esos árbitros jóvenes. Segundo, qué cualidades tienen. Y tercero, qué experiencia o no experiencia tienen para designar. Yo creo que cuando tenemos un elemento objetivo, como es el del puntaje que pueden haber tenido en un determinado momento, pues sin que eso implique la existencia de una experiencia, pues sí indica el interés en el arbitraje. De manera que esa cuestión de ICC Rewards, de alguna manera, tiene además del beneficio de obtener una recompensa, como las ha anunciado Andrea, pues también tiene el beneficio de irse acreditando dentro del universo o dentro del mundillo de los árbitros. De manera que, qué maravilloso. El Arbitration Watch, hombre, a mí en lo personal me da un gusto enorme el que ese programa tan extraordinario, que es el ICC Moot, que lleva ya varios años, tenga una continuidad. Porque, oye, es muy divertido y muy entretenido llegar al MUT, actuar como árbitro y ver cómo se desarrollaron los muchachos, cómo se desempeñaron. Algunos son unos muy buenos abogados y otros son muy buenos actores. Y es parte de la calificación, que también entraron al fondo, pero qué tanto desarrollaron y qué tanto llevaron a cabo su función de convencer a través de las pláticas, del diálogo. Hombre, pero esta idea de Edgardo me parece extraordinaria. Ahora vamos a concretar, señores, cómo se dictaría un laudo en este caso, tomando en cuenta los argumentos de las partes. Y yo creo que ahí es una forma extraordinaria, además del puntaje por la asistencia a los eventos, etcétera, etcétera, también el tomar en cuenta, pues ya en la práctica, cómo han captado el mundo del arbitraje, cómo han captado lo que es árbitro, ya sea con las reglas ICC o, ¿por qué no?, con las reglas de los Town Elders, que nos van a dar, yo estoy convencido, una dinámica nueva en la resolución de conflictos. Y en lo que se refiere al podcast, hombre, pues qué maravilla, volvemos a lo mismo de unir a esa brecha generacional. Me encantó, yo ya escuché las palabras de Klaus. Yo creo que cuando una gente como Klaus les puede decir a ustedes cuál es su experiencia, de dónde surgió esa pasión por el arbitraje, de dónde nos puede transmitir cómo es con el corazón, además que con el cerebro, cómo se llega a tener éxito como él lo ha tenido. Y caramba, entre todas estas 66 gentes que nos acompañaron hoy, no queda duda de que la inteligencia es enorme, pero el corazón tal vez más. El corazón de una juventud en la que va a poner su corazón encaminada a lograr un determinado propósito. Hace muy poco me llegó una plática, ni más ni menos que de Steve Jobs, en un commencement en la Universidad de California, y ni más ni menos que Steve Jobs decía, ¿saben qué? Para el éxito hay que lograrlo siguiendo indudablemente a lo que es su corazón, lo que es su pasión, lo que es su entrega por algo. Y yo creo que estos tres programas que han mencionado Eric, Nora y Andrea dan una plataforma para que ese corazón joven que todos ustedes tienen les permita tener un éxito enorme en el arbitraje. Yo no tengo más que felicitarlos nuevamente y ratificarles lo que ya les he dicho a su directiva, que cuentan con todo el apoyo de la Comisión de Arbitraje de ICC, que cuentan con todo el apoyo de la directiva de lo que es ICC México, y que estaremos muy pendientes de las labores que lleven ustedes a cabo para andar, ahora sí que, unidos en la mano, unidos en el intelecto y unidos, pues ahora sí que en el corazón y en la pasión por la arbitraje. Muchas felicidades nuevamente.
Muchas gracias, licenciado Garrio, por sus generosísimas palabras. La verdad es que estamos conmovidas con sus palabras y muy agradecidas y agradecidos por todo el apoyo que de verdad hemos recibido por parte de ICC México, de Jessica, de Laura, de todo el equipo de coordinación, de la presidencia directamente de Klaus von Bobeser y del comité de arbitraje del licenciado Garrio y de los demás miembros de la mesa directiva. De verdad, muchísimas gracias y no los defraudaremos en este proyecto en el que todas y todos los invitamos a que formen parte. Lo hacemos con toda la intención de poder generar una comunidad fuerte, darles herramientas para que todas y todos podamos formar parte de esta comunidad, y como parte de esa comunidad claramente se encuentran los vicecoordinadores y coordinadores regionales, que sin ellos el Comité de Jóvenes Árbitros no sería posible. Y quisiera nombrarlos y les agradecería que prendieran sus cámaras también para que nos acompañen el día de hoy. Está con nosotras Beatriz Valladolid, vicecoordinadora en el Comité de Jóvenes Árbitros de ICC México, que es asociada del despacho Ramos Castillo. También nos acompaña Javier Navarro, que es coordinador del Comité de Jóvenes Árbitros de Nuevo León, que es asociado de Baker & McKenzie. Nos acompaña también del Comité de Nuevo León José Alberto Domínguez, Muchas gracias por estar el día de hoy aquí. Y también Juan Carlos Villar Flores, coordinador del Comité de Jóvenes Árbitros del Bajío ICC México y socio de Villar y Villar Abogados. Les agradecemos muchísimo que estén el día de hoy aquí y es un atento recordatorio a todas y todos los que están en otros estados a que se unan a la comunidad de Jóvenes Árbitros ICC México. Esto es nacional, es para todas, para todos, y a que lo difundan, a que nos ayuden a difundirlo en redes sociales, nos ayudan a difundirlo con todos sus conocidos para que podamos hacer este proyecto pues de todas y de todos. Nada más agradecerles. Eric, no sé si quieras decir algo más. Andrea, muchísimas gracias.
Solamente muchísimas gracias a todos. Gracias por acompañarnos, de verdad. Estamos emocionados. Involúcrense. Escríbanos por Instagram, como dicen por ahí. Nuestros DMs están abiertos, así que escríbanos siempre. Denos retroalimentación. Crezcamos juntos. De verdad, muchísimas gracias a todos. Lau, licenciado Garrio, Edgardo, Jessica, Lau, muchísimas gracias. Andrea, qué gusto haber compartido contigo. Nora, desde luego, muy gracias. Y a todos nuestros comités regionales también, muchísimas gracias. Gracias a todos.
Gracias, Eric. Gracias, Nora. Gracias a todos. Y me sumo al agradecimiento de mis colegas. Gracias y buenas noches.
Buenas noches, gracias.
Hasta luego.